the idea of good governance, and probably the economists might disagree, but I'm a lawyer, so I think the core of the idea of good governance comes from the structure of government and the structure of a community, and for most tribes this is expressed in a constitution, not all of them. Constitutions are documents that are then the basis for other laws, and their provisions express fundamental definitional questions, stuff like who constitutes the people and how will disputes be resolved. So we can talk at length in the abstract about what these kinds of documents might look like in the process of adopting them and updating them, but what is missing very often are the stories of tribes who have actually done this, been through it, who can share what worked, what didn't, and how they answered some of those crucial questions that are shared by many tribes. And so we are actually very lucky to have panelists here who can do just that today. They will shift their order. We're going to do this in kind of a roundtable format, so let me just give a really brief introduction and then they will each say more. Starting with Jill, we have Jill Doerfler, who is an assistant professor of American Indian Studies at University of Minnesota in Duluth. She is the author most recently of Blood versus Family, The Struggle Over Identity and Tribal Citizenship Among the White Earth Anishinaabe, and we'll discuss the White Earth constitutional revitalization process here. We have Devon Lomayesva, who is a staff attorney now for the Soboba Band and formerly was the director of California Indian Legal Services and in-house counsel and also a tribal council member for the Ipe Band of Santa Isabel. And she will discuss their constitutional revitalization process at Santa Isabel here. And then Melissa Tatum, who is research professor and director of the Indigenous Peoples Law and Policy Program at University of Arizona, is our generalist today. So Melissa's work focuses on jurisdiction in tribal courts, and she most recently is co-author of a book called Structuring Sovereignty, Constitutions of Native Nations. So she will talk about broad trends, sort of fill in some of the broad and historical questions, and then also draw on some of the stories that are outlined in the book that is forthcoming. So I will, I'm a wordy moderator, but this time I actually want to hear so much from them that I'm going to say very little more. What we're going to do is I am going to ask 5 questions. So with our first question, we'll hear 5 minutes from each of them, and then there'll be 4 follow-ups, which they'll give varying lengths of 3 to 5 minute responses, and then we'll hear from the audience. So it's a little different than your typical panel. So we ask that you try to hold on to questions until the end. We're hoping to get to some of the major issues through our roundtable format. So I will sit down now and ask my questions from the back, and you all should feel free to come up, especially for the first question, or sit down if it's easier. So the first question I wanted to ask the panelists to talk about is just to give us some context for thinking about constitutional revitalization in Native communities. So what is the historical context? What political and demographic forces are shaping the process of reform for tribal communities? And more specifically, where is the push for reform coming from? If it's coming from within or without, and sort of what's the story behind that? So I'd like to ask you each to talk about 5 minutes about that.
Yeah, we were just sort of doing eye contact, and rather than spend time getting up and down, we'll talk from here if that's okay. It's hard for the people who are behind us. As Addie mentioned, I work at the University of Arizona, where we have an Indigenous governance program where we bring people who are working with and for tribal governments. And one of the we have different academic programs for the a graduate certificate and a master's degree. And one of the first things we decided to do when we were putting together that program, and Mary Jorgensen is here behind me, she's one of the co-directors of that program, we decided that we really needed to have something on constitutions, and something focused on constitutions, because that is such a major issue. There is an increasing attention around the world, as we heard this morning, on constitutions and the role of constitutions in providing a framework for government and ensuring that that framework is an appropriate one. There are 3 general eras. I mean, there are always exceptions to the rule, but there are 3 general eras of tribal constitutions. There was a wave of tribal constitutions before the Indian Reorganization Act. There were the IRA constitutions, and there are a wave of constitutions that are being adopted in the self-determination era. And one of the things that was a touchstone that we always go back to are the IRA constitutions, how they were boilerplate constitutions for the most part. There actually recent studies have shown they weren't maybe quite as boilerplate as we've been thinking, but many of them had similar problems. They have a very simplified government structure, an overly simplified government structure, in which the power is concentrated in ways that are not necessarily appropriate. The business and government functions were often intermingled in those constitutions, and they have the secretarial approval clauses, which present a problem for a variety of reasons. Most importantly of which is, why should the federal government and the secretary have the right to approve or disapprove a tribal constitution that's been adopted by the tribe and citizens of the tribe? But the most important problem with these IRA constitutions is a lack of cultural match. Most of the institutions they created for government systems didn't work for the tribe. As we've heard this morning, that cultural match and that need to be appropriate for each culture is critical. And so one of the problems that has been created by these constitutions and by the drive for reform is that there are incentives and disincentives to government structure and government change. And so not only must you have the drive for reform, the people who are doing the reform have to have the ability to influence that change and lead to that change. And there are a wide variety of tribal examples of different ways that they've dealt with that. And I'm going to, at this point, I'm watching time very carefully, stop my part and turn it over to Jill and Devon.
Well, good afternoon, everyone. So today I'm really going to focus specifically on my tribe's constitutional reform process, but I want to say just a little bit about California specifically, because that's where I have exclusively practiced Indian law. California has a very unique history, for those of you that are familiar or not familiar, with over 100 recognized tribes and heavily hit by the termination era, especially in Northern California with the rancherias. The tribes here never had a ratified treaty, and so are still today in various stages of tribal development infrastructure-wise, tribal court development-wise, and certainly constitutions. Many of us still have the Articles of Association. Even those of us that aren't IRA, my tribe is one of them, still ended up adopting IRA-type constitutions or articles, as again, most of us had here at least at one point. So it's very important, and we talked about this on the panel, that you have to understand the community. And as the speaker stated earlier, you can't just do a one-size-fits-all. And I'll explain later why that is something that I would argue, at least coming from my community, happened to my tribe, is that we got kind of a cookie cutter. And it wasn't before the IRA, it wasn't during the IRA, it was a few years ago. And so when you put together your community committee, your tribal attorney, whomever is going to be in this process, you have to make sure that it might look great, it might look like it's an actual committee that's out there. We got this little picture here that was sent to all tribal members of the committee here with the attorney at that time, and it looked great. But I can tell you now, several years later, that it wasn't as representative of the community as everybody had thought. And you're going to have growing pains, of course, when you take over something this huge that's never been the way that you've governed yourself. But there's been some good things as well. So knowing your community, making sure the people you put in place, because even if you say, well, the attorney's there to guide it, and I'm an attorney myself, but also a tribal member. And I just remember during the time that we were talking about this, I had some opinions on how the drafting was going, and they said, well, you're not here as a tribal member, we pay you to be our tribal attorney, and you're not on this project. So it's kind of like, okay, I'll never forget that. And I don't, and I use that as an example because lived on the reservation, lived off the reservation, have been on every committee you can imagine, and continue to do that today, and feel like I know a little bit about it. Whereas the other attorney did not. So you have to be careful, and we've learned a lot, and now we're at a point where we're going back and saying, wow, we really didn't think this out practically. Like put a provision on the board and say, how are we going to do that? We didn't do that process, and I can't say enough how important it is to take those things that are really key and put it up there and say, how is this going to practically play out? How are we going to pay for this? Because the reality is, half of our Constitution we're not allowed to comply with because we don't have the money, and that's just the bottom line. So that's going to kind of be the backdrop to a lot of what I'm going to talk about, so I will just end there.
Great, thanks. So I'm Jill Doerfler. I'm going to talk a little bit specifically about my nation as well, the White Earth Nation, and our recent constitutional process. White Earth has had several efforts for constitutional reform over the last few decades, and they've been motivated by a variety of factors. White Earth currently participates as part of the Minnesota Chippewa tribe, which is 6 Ojibwe or Anishinaabe or Chippewa nations put together. And that constitution, for a variety of reasons, White Earth has found to be quite ineffective. There are some representation issues. White Earth has about 50% of the population of the Minnesota Chippewa tribe, so we're very populous, and we have the same 1/6 vote that tribes who are significantly smaller in number have at the Minnesota Chippewa tribe level. And then there are broad issues with the Constitution. I think the Secretary of the Interior is named more than 20 times. There's no separation of powers, and yet since self-governance, each of the 6 nations has really gone and done on its own self-governance agreements, establishment of court systems, gaming compacts, etc. And so for a lot of reasons, I think tribes have been sort of working around that MCT constitution to some extent. And so there's a desire at White Earth to make change, for White Earth to have its own constitution, and maybe to continue to participate in the Minnesota Chippewa tribe, and maybe not. And those issues remain a little bit unresolved today. So we're still working on that. So we have that push coming from that angle. We also have the leadership of our chairwoman, Irma Visner, and we heard Joe Call talking a lot about the importance of leadership, and in our case at White Earth, Chairwoman Visner's leadership has been absolutely essential. There was, we would say, a crisis at White Earth in the late 1990s where many of our elected officials were convicted on a variety of charges, including election fraud and bid rigging, etc., went to prison for those violations, and Irma Visner came to power after that, and she was involved in holding some of those leaders accountable for those illegal actions. And she, and I think that people of White Earth saw the need for constitutional change, for a separation of powers, for more levels of accountability in the Constitution, because we were left at White Earth with a system where something could happen exactly the same as had happened under the former administration. And so there was a desire for change. And she was elected on constitutional reform platform several times at White Earth. So it was both a desire on the part of the people, and then I think her leadership that also helped carry reform forward at White Earth. So we have those variety of factors, the issues related to previous fraud activities, ineffectiveness of the current constitution were all playing a role in the new effort for reform at White Earth.
Okay. I'm the phantom in the back over here. So first of all, panelists, great job. You were all about 3 minutes there, so you're doing that. So question number 2, if any of the following questions are questions that any of you panelists want to sort of not address, that's fine. We talked about there being certain ones that some of you wanted to address at length, or feel free to give a short answer. So the second question I have is to give us a sense, and we've already heard a little bit about it, but of the goals of these revitalization efforts. So, for example, how important are internal pressures? Pressures like the desire to incorporate tradition or to achieve this cultural match that we keep hearing about. Mm-hmm. On the flip side, are the efforts mainly a response to outside pressures, or how much are they a response to outside pressures? So the need to be perceived as a non-racial community, the need to be able to prosecute people under new laws, the need to support economic development. Are there outside pressures that are driving these reform processes, or inside pressures, or both? To what extent do you see those playing in?
I think it's, regardless of what sparks the change, and I think all of these are things that have sparked change in different communities, I think it's important when tribes are reforming their constitutions or creating a constitution to remember that ultimately the Constitution serves several key purposes. The Constitution defines the relationship between the government and its citizens. The Constitution defines the structure of the government. But ultimately, a constitution is an expression of the identity of the tribe and of the community. And regardless of what the pressure was that sparked the change, you have to make sure that your constitution takes the larger view and doesn't just respond to whatever that one pressure was. It's ultimately, you've got to have cultural match and efficient institutions. And efficient institutions are not just institutions that get the job done, they're institutions that can survive moments of crisis. The government has to be more than the one person. The government has to be a structure that survives regime change. And if external laws may want to, a tribal community may want to have external laws be part of or influence their constitution, but if I strongly suggest that if tribes want to incorporate the UN Declaration on the Rights of Indigenous People or the Indian Civil Rights Act principles into their constitution, they do so as tribal law. They don't do so with reference to the federal or the international law, and because that gives the feds or the international community the ability to change the definition of tribal law. It needs to be adopted as a principle of the tribe and of tribal law and interpreted by the tribal judges and the tribal courts and the tribal legislature as tribal law.
So for San Isabel, I mean, it's exactly, we did exactly what you said not to do, which is draft the Constitution based on one thing that's happening. And what was happening, of course, was the casino. So everybody was excited that it was coming, and during the process of negotiation, because we had these articles that were, of course, like, you know, a corporate structure, there wasn't much in there that made the bank and all the investors feel good about being able to collect if something happened. So we said, okay, we got to put something together so we're more attractive to do business with, and then it turned into a full-blown constitution. So it was very, they took a while to put it together, you know, I'll say that. It took over a year, so probably should have took longer. So it was really based on, you know, that economic development incentive, which is a legitimate incentive, but in the process, we overlooked a lot of the things that we all know should have been more considered. And one of those things was, well, you don't get rich once the doors open. And as we learned, you might never get rich and then it closes. And that's just what happened to us recently. Our casino closed. It failed miserably. So now, you know, we have this document that was created to bring that in, but yet nobody's going to do business with you when they know you don't know how to run the core business. So it's kind of backfired in that way. But see, this is still what we have to live by, because the provisions that were put in there for change, to amend it, are so stringent that it's basically impossible. And unless you were to tell everybody you're going to pay them to show up at a meeting to vote on it, you're not going to get the people that are required to be there in order to amend it or overturn it in any way. So the impetus for it, you know, really ignored the cultural and the traditional way that we governed ourselves. And although we had governed ourselves by these articles, that became our tradition. And it was very general counsel based. It was the people making all the decisions. But even if you look at the Constitution, it sounds great. It says the general counsel shall be the supreme governing body of the land. But then if you read further, you see that the general counsel basically doesn't get to do anything until a bill is you know, thrown out there by the legislature. And only after it's published can the general counsel, with 2/3 signatures on a petition, even challenge it. We can't even get a quorum at our general counsel meetings for the last 4 years, let alone get 2/3 people to sign a petition to turn over something and then show up for a quorum to vote on it. So it's really disenfranchised the people, and that was obviously an unintended consequence and not something that's document purports to push. So the impetus for ours, you know, was very reactionary, and it just hasn't, you know, worked out the way we thought it had. We let outside pressures, you know, required MOUs with the county for gaming really influence, you know, the way we kind of worked through it. And so hopefully, if we get to the point where we're able to amend it and revise it, we can take the time to think on a larger level about what's important and how we can give the people a voice again in the decision for the tribe.
Right. So with the situation at White Earth, I should say that I realized all the things I neglected to say during my little intro in the interest of time, that the new constitution was just put up for a referendum on November 19th, 2013. And at that time, the percentage who voted in favor was 80% and then about 20% opposed. So we have a sort of landslide election, a sort of mandate to work on implementing, but we haven't gone through that process yet, hence why those questions with the Minnesota Chippewa tribe and some other questions are still looming. Most of the pressure for the new constitution for us at White Earth was internal. And the effort, the most recent effort previous to this effort in the late 1990s was a really response to the crisis of the elected leadership and the variety of things that they were convicted of. And there was an effort for reform at that time, and it didn't work. People weren't ready for it, I think, because it was just too reactionary. People were still kind of recovering from all of the variety of issues that had come about in the late 90s. So in the late 90s, that Constitution Reform Committee had created a draft constitution, and they had done some community meetings, and they had done a variety of education efforts, and then things sort of sat for a while. People weren't really ready, and our chairwoman just felt that the tribe needed just some time to think things through, to evaluate, and then we would be coming back to it. And so that's why when the current effort for reform started in 2007. And there was a big desire to incorporate tradition, because the Minnesota Chippewa Tribe Constitution, many people felt, did not incorporate any traditions or values. The leadership on the reservation is tribal council, 3 districts, and a secretary treasurer and a president, or chairwoman, I guess we say. But for example, the 3 districts are basically chosen by the way the highways divide the reservation. So not indicative of anything internal, not necessarily how we would want to draw community lines for elected leadership. So there was that desire to rethink, say, what is now termed the Legislative Council under the new Constitution. What would representation look like if the people of White Earth got to decide? Which is what the Constitution says. The Constitution does not lay out a prescriptive set number of districts or communities, or what it says is the people of White Earth will get together, petition, file petitions, and then there will be another referendum election where those communities who receive more than 50% in a referendum, then they will elect a representative to the Legislative Council. So it even leaves it open to that point where the community will still be involved in deciding that, and it contains a provision that says that's going to change over time. The communities will be established and changed by petition and referenda. So it tried to be flexible with that. There was interest on the part of many people in using our traditional clan affiliations to maybe set out the structure as opposed to geographic. We don't know what's going to happen, what people are going to want to do when it comes down to it, how that's going to play out. But this summer we'll be working on that process of doing some survey work and some other community meetings to think about how do people want to organize? What does that look like? What's going to be an effective number of representatives? That's a big question for us. And so those things will be through that process worked out. So we had that internal pressure, definitely the desire to incorporate tradition, basic Anishinaabe teachings, relate really easily to accountability, which we tried to build in. It's interesting because I think some people read the White Earth Constitution and they think that it looks very much like a sort of classic separation of powers kind of branches of government, which is true, but embedded within the idea of checks and balances relates back to our traditional principles of accountability and working together, and so it's in there, it's just not maybe as overt, so it's not always that recognizable to some people. So we work to incorporate that as much as possible, and that was a big challenge, because I think everyone says we want a traditional governance structure, and the question is, what does that look like? How can that be effective today? How can we translate that? There are a few people who are interested in going back to the hereditary chief system, but really that's a small minority of people, and so how can we think about a system that has traditional elements and basic traditional values, but is effective in the contemporary world?
Great, so you all set me up perfectly for the next question, which is that I wanted to invite each of you to talk a little bit more about what structural models emerge. So we're hearing about the need for efficient and responsive and culturally matching institutions. What did those institutions end up looking like? And so this might be a story of an institution that you think worked really well or one that didn't, but what actual structure came out of these constitutions?
I think one exercise that Miriam and I use when we teach the class is we divide the class up into groups and give them a constitution and say, go diagram the government that this constitution creates. Mm-hmm. And then talk about what kind of community you think that structure is best suited for, and is that this community? So start looking at that idea of structure and to understand how to extract that structure from the Constitution. And a lot of times the U.S. Constitution is held up as a model for a Constitution, and I think it's really important to remember the context for the U.S. Constitution. When the U.S. Constitution was drafted, it was not intended to be the document that for the government that ran the day-to-day lives, because the state governments were the ones that legislated for the day-to-day lives. So the state constitution would be a much more analogous example. Now, it's through the way our government structure has emerged and developed, the U.S. Constitution has started to emerge become that central role. But that's not what it was intended or drafted to do. And I think it's also important because everyone talks about separation of powers as it's embodied in the U.S. Constitution as an ideal or as a goal. And I think the two things that are important to realize with that respect is separation of powers is not a Western European invention. And separation of powers can happen in a wide variety of different ways. The important thing is that a government has to fulfill three functions. The government has to have a way to make law, to legislate. The government has to have a way to enforce and implement the law, some sort of executive function, and the government has to have a way to resolve disputes, a judicial function. But those do not have to be separated into an executive branch, a legislative branch, and a judicial branch. Mm-hmm. They can be split up among various different branches in different ways. You can have a 4-branch, a 5-branch system of government. You've got an elders council or a youth council. There are a wide variety of ways of dividing up those functions. And separation of powers is how you balance those functions between the different groups. I did a lot of work when I was at the University of Tulsa with the Muskogee Creek Nation. And Muskogee Creek Nation has historically had a separation of powers and had very interesting separation of powers. One of my students in the master's program there wrote his dissertation or his thesis on the historical separation of powers in the Muskogee Creek Nation. And they had red towns and white towns. And which town was in control depended on whether they were peace or war. This was terribly confusing for the U.S. government, who showed up and said, let's negotiate a treaty. So they did. The U.S. breaks the treaty, and they show up, and the people say, you broke the treaty, we're at war, you gotta go up the road. They're running things now. The red town's in charge. And it was a very sophisticated government and a very sort of different way of dividing up functions between the different structures. But I do want to point out that we talk about individual rights and protecting individual rights in the Constitution. But one thing that we might want to think about is, should there be responsibilities of citizenship outlined in the Constitution? And that's going to depend on each community. But that's something to consider as well, is because many communities, there are responsibilities of citizenship as well as rights.
Well, I am going to jump up here really quick just because I have a picture, which makes it, this is mine up here. and I'll just talk through this really quick. So this is what we had adopted in 74 and had some various amendments. And this was actually what was put out in the packet that was mailed out to all tribal members when we were voting on the Constitution. And you see it starts right off the top. I mean, obviously they wanted people to vote for this, right? So they put, of course, the big bad BIA on top to show, look who's over you right now. Well, actually that wasn't necessarily the case, because in one of these amendments, we got rid of BIA oversight in many areas, including membership or amendment of the articles. So that wasn't necessarily the case anymore. Then it had the Articles of Association, which we were governed by, our General Counsel, which all our voting members, the Business Committee, also known as the Tribal Council, and then the Chairman, and then all these other, departments. And so what the push was to switch to, and I will say, just really quick to go back to another question, the one cultural thing we did was we changed our name for the second time from, we originally the Santa Isabel Band of Mission Indians, and then we went to the Santa Isabel Band of Luiseño Indians, and then now we are the Ipe Nation of Santa Isabel, Ipe actually being one of our native words that means people. So the way it was pushed was Constitution, and then, wow, look, the General Counsel's only second. But again, when you go back, the General Counsel is really at the bottom because of the heavy voting requirements and quorum requirements and 2/3 majority requirements. A lot of things happened to the tribe in between 74, the amendments, and 2005 when this was being presented. We actually had a change in our enrollment ordinance. We were originally the 1940 census, which was what everyone had to come through to be able to be enrolled. But we opened it up to like 10 other census from California. So that dramatically increased our tribal size. So the 10% quorum required under the articles, we only had to have 18 people there for a quorum. But after all these other additional people were enrolled, we need 60 for a quorum. The only time there's ever been 60 people at a meeting was during the votes on the casino, when everybody was getting a full-on breakfast and, cute little pens and pencils. And I mean, I'm sorry, but that's really how it goes. And since then, we haven't had a quorum. We haven't had any breakfast or coffee or anything, and you get no one participating in the meetings. Nothing's passed out to anyone. So what we thought was going to be, wow, General Counsel's second, is really you're off the chart now because you're not even able to make a quorum. So another part of the structure, the separation of powers, it was obviously the Western model of legislative, executive, judicial. And then with the judicial, I'll talk about that a little bit later if I have time. It looks set up great, and then you have resolutions and the budget, and all these down here are the departments, which I'll talk about later. Mind you, not one of those has been implemented to date, and that's been since 2006. It's now 2014, and we haven't been able to appoint anyone to these departments. So that was kind of how our structure was presented, and it just didn't turn out, to be that way. I will say that joining what is the Intertribal Court of Southern California, where many of our Southern California tribes are members of, which I've recently been appointed pro tem, I'm really excited about that, is to, we finally have somewhere to go, and we've used that tribal court a lot, and we've actually been to court a couple times on our Constitution to interpret core provisions because we were stuck as a people as far as being able to, how does this govern us, and how do we interpret that? So we've actually utilized the court to do that. Although we have expired the time that we're supposed to be allowed to use the Intertribal Court, we were supposed to only be able to use it for 36 months after the implementation of the Constitution. We have no choice. We have no money to have our own court. And the way the Constitution was drafted, we had this enormous amount. I mean, we had to have an appellate court, a trial court, a chief justice, 2 appellate justices. Then the appellate court, I mean, it was on and on and on. I mean, that's more than the intertribal court has, and they have over a dozen tribes that are members, and they don't even have that number of justices within the court, let alone the court clerk and all the infrastructure we all know it takes to keep a court in place. But at any rate, we're still using the intertribal court, even though it's been more than 36 months, because we have no other option. The only other thing I want to say about the structure and some things that have emerged that have been a good thing is our jurisdictional statement was a good jurisdictional statement that we didn't have before, and we utilized that to pass a children's code, which basically we take jurisdiction over any child, no matter where they are essentially in the world. As long as, of course, we don't run into those issues in ICWA of the parents' veto rights, we will take jurisdiction over those children into tribal court. And we've taken children from Pennsylvania, New York, Texas, and brought them back to tribal court and found family members locally that were previously being ignored. So that's been a really good part of it that we've been able to put into place. So I will stop there.
Right. So with regard to White Earth, as I mentioned, the separation of powers was one of the key elements that people were kind of looking for because of that variety of issues of fraud and illegal activity. One thing that people really wanted to see in the new constitution relating to the justice system, White Earth already has a court system, but it's set up basically just by tribal council resolution, which can easily be changed at any moment in time. And so people wanted to see that court system be more independent so that they could, and I think rightfully so that people can trust going there, that they're going to get impartial or as impartial as possible decision. And also people really wanted to see restorative justice as opposed to this adversarial system, which, as Matthew talked about, often doesn't really work, and people at White Earth really felt that way. And so written into the Constitution is a clause that also says, whenever possible, and we list the variety of places where restorative justice will be used first and foremost. And so that was something that I think relates back to cultural match as well as the separation of powers, where we see those things aligning together to work it out. The other thing I'll say regarding individual rights is that was also a concern at White Earth. Many people would argue that there isn't currently basic freedoms. Many people feel are not protected currently, and so there is Chapter 3 of the Constitution is citizen rights and responsibilities, and laid out in there are certain basic principles of freedom of speech, but then we also have some more clear protections and some things that people find interesting: freedom of artistic irony and all kinds of expression, freedom of electronic communication, these types of things listed as well, which I think connect back both to that cultural match and to the separation and rights and responsibilities.
Thank you. So we have technically until 2:30 now, because we're allowed, we started 15 minutes late, but I said that we would try to be fast. Our panel has been, this is my favorite panel ever. So timely. But what I want to do is I have two more questions, but I think I'll ask one, and then I'd like to open it up because there's a lot of people in the audience, and I think it'll be good questions. And if I have time, I'll ask the last one, but let's make sure that we get some good time in for questions. So the last question that I wanted to be able to ask was about the membership / citizenship / enrollment issue. So the question of who will comprise the political community is one that sort of has to be wrestled with in a constitution, whether it's sort of the focus of reform or not. So federal law is relatively clear that membership and enrollment is a question of tribal law, but the issue is always kind of the focus of outside scrutiny and inside criticism in a lot of tribes. So it's a hot button issue. How big of an issue was this for each of you? And what options did you consider? What was the goal of reform? What happened? Jill, I obviously want to start with you here.
Okay, great, sure. So my tribe citizenship was a big issue, and I actually got involved with constitutional reform at White Earth because of citizenship, because my research for my PhD was on Anishinaabe identity and citizenship, and looking at how the Minnesota Chippewa tribe came to adopt a blood quantum rule in the 1960s. And so I was interested in looking at that, and since that was adopted in the 1960s, there has been a significant impact on families at White Earth. Everyone has someone in their family or somebody that they know that is not enrolled because they don't meet the blood quantum requirement. And the tribe recently had some population studies done just in 2012 looking at the demographics and the current population of White Earth. 75% of our population is 45 or older. And so that's in contrast to many tribes have a younger population. That is not the case at White Earth, and we're clearly, that research confirms sort of what everybody knew on the ground, is that this blood quantum rule is having a significant impact. And so during the constitutional process, I wrote a variety of newspaper articles sharing some research and how the Minnesota Chippewa tribe came to that blood quantum rule, which was really heavily impacted by the federal government. The Minnesota Chippewa tribe employed a system basically of lineal descent, and the federal government kept sending letters stating the Minnesota Chippewa tribe needs to clarify their process. It's not, we don't have enough paperwork sort of going on here. And the Minnesota Chippewa tribe passed a resolution stating that it would be lineal descent, and then that would get rejected by the Secretary of the Interior because you can't make that change to a constitution without secretarial approval, as the Minnesota Chippewa tribe constitution states. So there's a little bit of back and forth in the 40s and into the 50s on that, and then we basically see some strong arming, and the Minnesota Chippewa tribe sort of out of nowhere just agrees to blood quantum, even after taking a stand and actually arguing that the Bureau of Indian Affairs shouldn't be using quarter blood quantum for some of their programs as they were doing at that time. And so we get that implementation, and so many people have been against that even since it was implemented. So that was a big issue that we were looking at. And during the Constitutional Convention process from 2007 to 2009, where we held meetings and delegates spoke on these issues, citizenship was probably the most controversial. People can pretty easily agree on separation of powers at White Earth. People were like, yes, we need that, we've had these problems. Citizenship was a little bit stickier. People primarily talked about their families, the importance of family, back to our traditional values. What about children and grandchildren and future generations? And so there was that argument made in favor of lineal descent. And then there were other people who sort of supported that idealistically, but they were afraid of it in practice because of resources. And so they would say, yes, but what about, how are we going to afford to basically pay for all these people? And so we have to think about citizenship not just about what somebody gets, but what they contribute. So not thinking about citizens as a drain on a nation, but thinking about citizens as people who contribute, people who can make the nation stronger. And so we had a variety of discussions about that. Delegates looked at probably 6 or so different options for citizenship. Most of them were a variety of blood quanta kind of calculations, and then lineal descent. And ultimately, at one point during a heated discussion, one of the delegates just made a motion and said that they don't want to discuss blood quantum anymore. It passed. That left us with lineal descent. And so then in the Constitution, the provision for citizenship is lineal descent. And then we also have a clause that relates to these concerns about resources. And so there's also a clause on services and entitlements, which basically states that services and entitlements will be governed by a variety of laws. Sometimes it's federal law. If you're accepting federal dollars for HUD housing, you have to follow federal rules. State programs, you have to follow the criteria. For tribal programs, White Earth will make its own criteria, not every single person is going to qualify for every single program. If we have an elderly nutrition program, you have to be of a certain age, you probably have to live within a certain area, you maybe have to have a certain income requirement, etc. Which is essentially how things are run now, but I think having that clause in there just reminds people that that these things will be governed by a variety of criteria, and that no one is entitled to really to anything necessarily. And so we addressed that issue to kind of balance it that way.
Well, I already alluded a little bit to membership wasn't a driving force in our Constitution because we had already just went through an enrollment ordinance revision and kind of hammered that out, which was very heated. Same thing, well, if all these people get enrolled, when the casino's up, we're not going to get as much money, the typical, the drain or taking the entitlement type of thing. But we got past that, and we actually ended up enrolling at least 150, if not 200 more people that were legitimately, descendants of our tribe. You just happened to not be around the day they did the 1940 census. You got left off, but you happened to be around in 1920 or 1919, so now you finally got enrolled. So that wasn't a big part of it. It is obviously in our Constitution, but the good thing about it is it did develop a base role as of the date the Constitution was adopted. So now, hopefully, the Enrollment Committee, we are no longer constantly going back to the 1940 census, which has scratch outs and initials by who knows who initialed it, somebody somewhere at some point. And the craziness with trying to understand what the census said. Now we have a base role, and those persons are essentially protected, and their members and anybody that flows from that. We do have a blood quantum, but that went through rather easily. So I'll leave more time.
I'll just wrap up really quickly and just extract a couple of things out of what their example showed. You've got to have a way to define who's a citizen at the start of the government, how people can become citizens, and how people can have their citizenship revoked or can choose to surrender their citizenship. But the question is not just how you want to do that, but to balance what's in a code versus what's in the Constitution. Because some of it you might want to make harder to change and put it in the Constitution. Some of it you might want to make easier to change and put it in the code. So that needs to be part of the discussion as well. And I'll just leave it there.
So I'm about to open it up. I have two clarifying questions that I'm going to use my prerogative to ask, which is, Jill, so you were saying there's one citizenship provision, but then one provision saying, other parts of federal, state, or tribal law might govern eligibility for certain services. So what do people get as citizens? Is it voting and running for office? Is there anything else? What goes along with citizenship that isn't changed by the other laws?
Yeah, I would say, voting and citizenship.
Voting and
And
run for office.
And running for office. The criteria for running for office is being, I think, 24 years old and no felony convictions.
Okay, so that's limited.
Yeah, it is limited.
And the other clarifying question I have is, Devon, you alluded to having a good jurisdictional statement in your Constitution, and then you didn't tell us what that meant. What was good? So I would love to hear about what that statement was like and why it was good, and then I will just start taking hands. If when you ask questions, you could speak up because we have a tiny recorder up here. That would be great.
Well, I guess good was in compared to basically nothing in the previous. But that being said, it really encompassed, I don't have time to go into it, but the history of our tribe and our lands is that we have 3 separate tracts, tracks 1, 2, and 3. We've been in litigation with our neighboring tribe for decades. Over a land dispute, but the land, all 3 tracts were issued to us at the same time, have always been our reservation. They've always felt that it was done wrong, but they've lost every time. And whether we agree or not, we're not willing to give that land up. I mean, we have our members that live there, our family members that are buried there. So that all really related to the jurisdiction, and previously that wasn't articulated in a way that solidified the fact that this is our land, because we've been so open with this other tribe, and because many of us have families that come from both tribes, because we're right next door to each other, we've, allowed them to build their fire station. They have, basically their tribal office on our land. We've allowed them to get funds, and in that goodwill, it kind of came to bite us because they said, well, look, we get these funds, we have our fire station. So anyway, the jurisdictional statement really clarified the tracts and the area that was our, ancestral territory. And I think that's why I'm saying it was good, because we'd had issues before, and that's kind of how we used the jurisdictional statement in the children's code. So that was essentially.
Good. Thank you. Okay, questions?
For Jill, were you at the poster sessions last night at all?
Mhm.
Yeah, so I think the presenter might be here who had the poster on White Earth. And I talked to her, you mentioned the 80 to 20 vote in favor. In the poster, she alluded to the fact also, however, that whatever the 80-20 was split among those voting, she mentioned that she thought the percentage of people voting at all was low. Is that true, and is that an issue?
Sure. So in an average election at White Earth, about 10% of voters who are eligible choose to vote. In the referendum on the Constitution, about 20% voted. So we had about double the voter turnout that we would have to elect anyone for elected office. And so, there's probably a variety of opinions on any election and whether the 10% that we get on a regular basis. I know there are people who argue that that's not enough to have currently elected legitimate leaders. And so I can see where somebody could potentially make the same argument here, that about 20% is also not enough. So people are entitled to their variety of opinions on that.
Yeah, I have a question, and maybe this is too esoteric. So, nobody really wants to use the United States as a model, but I'm always fascinated by the fact that the Constitution is a product of treason. I mean, they met in secret for weeks, and nobody ever really got rid of the Articles of Confederation. So, I know with my tribe, it is almost mathematically impossible for us to amend our Constitution even for the smallest thing, like to take out the secretarial approval provisions. So why can't we just ditch the whole thing and start over? And I guess it's a function of what each tribal community's politics allows, but is that something you guys have considered as a possibility?
We have, those of us that have seen, and we have a couple of attorneys in the tribe and others that, various disciplines, and we said, well, to amend it, you need 2/3, but it doesn't say what you need to completely just get rid of it. Because really the people are that unhappy with it. Going to a general council meeting, I was late last month or the month before. I brought my whole family, and they started laughing at me when I woke up. They're like, it's over already. When I drove up, they said, it's over already. So, but again, there hasn't been a quorum in over 3 years. So this whole nonsense of general counsel being right there is, and everybody sees it. From the elders to, even the kids, they used to come and sell food for, the youth program. Nobody even does that anymore because nobody comes. And there's, you got 10 minutes to sell all your stuff. So we've really explored that in just saying, well, what's stopping us in here from just drafting up something new, maybe actually taking the old one again. Now we're like, oh, that wasn't so bad. Maybe we should just have done a corporate code, and that could have solved some issues. But yeah, I'd love to have ideas on how we can accomplish that, because it truly has, half the time we don't even know what laws are being passed. We have a good group of legislatures, but out of the 7 that are supposed to be on it, we've struggled to maintain 3 or 4. Those departments that are mandated under the Constitution have never been filled. Because do you want to be the director of land, services or cultural resources if you're not going to get paid? Of course you don't. And if you get a volunteer in there, what are they required to do? So all the meat of it it's not there. I mean, all the requirements for a tribal court. I mean, we're forced to violate our own constitution. And people say, well, you're not following it. Well, do you have the money it takes to fill these positions? But anyway, yes, we've thought of it.
Yeah, that relates a little bit to our situation with the Minnesota Chippewa tribe and questions about how that is going to proceed or not. There is nothing in the new constitution that prohibits White Earth from participating in the Minnesota Chippewa tribe. That was purposeful, but it's clearly governing under a different system. There is no provision for secession from the Minnesota Chippewa tribe either, so the question is, can that be done? How can that be done? Or can there be a way for White Earth to continue to send the 2 reps necessary to MCT and continue to operate that way? So.
One of the things, I know my tribe has explored taking on constitutional change and revision, but what we noticed is that there was a tribal attorney that came in to our tribe and followed San Isabel's model, almost cookie cutter type of thing. Then we found out that also he was over other tribes too.
Mm-hmm.
Can you explain more about that with how that your attorney at that time proposed your constitution?
Yeah, and I had kind of alluded to this before, that you got to know who's coming in and what they're bringing in and how much is the community really involved. Because if you look at our Constitution now and you look at what was proposed at Hopi, and this is my husband, by the way, Hopi and my tribe are like night and day, culturally and government structure-wise. And to have something that's very similar makes absolutely no sense from cultural or governmental point of view. And then if you go to this attorney's tribe, again, further, completely different, and then the other tribes that it was brought to. And so you bring in a group of the Constitution Commission that's appointed to do this. And many of them have never been around the reservation. And I don't say that as a bad thing, but the reality is that the Constitution, it has to do, I mean, the land that's your lifeblood, that's where you connect, that's where you're from, that's where things flow from. Some of the people lived on the reservation all their lives, so we thought we had a good mix. But if you look at who's on who was on that committee, most of those people are not around and never have been around to see kind of what's happened. And they kind of, Matthew was talking about shutting the doors. Well, that happened with our committee. And we weren't all allowed to just show up and listen. We were told there's not enough room, you'll get to come to the community meeting. So it's kind of like, well, what's going on here? So, your people, I mean, we have to be accountable for what we do and the decisions we make, but you also have to watch out for the people out there that are just trying to sell you something that's already been done that's not going to fit your people. Because they get to leave, but we're the ones that are left there when the people are saying, you were a part of this. I mean, I have people saying that I was a part of it. I said, no, remember they told me that they don't pay me for my tribal member opinions. So, you have to be really careful. And Indian, non-Indian, it doesn't matter. What matters is that they come and they listen, and like, I'm forgetting his name now, Joe Calt was saying, get out in the field. Mm-hmm. You can't do this, via email. So yeah, I think that was really, really a huge reason why we have what we have now, and we're dealing with the remnants of it.
Yeah. So go ahead.
Oh, I was just going to say, our process at White Earth is almost exactly opposite of yours. So I'll just say briefly that, when the chairwoman called for constitutional reform, she, first of all, asked each of our community councils to send representatives, and then people could apply to become constitutional delegates just via an at-large process. And so about 40 people expressed interest everyone who expressed interest was welcomed to join in and do this work essentially for free. You get your meals, of course, but you're coming to spend your Saturdays dealing with these hard questions of what is this going to look like, who are we, etc. And so we didn't bring in, we really had very little outside participation. We brought in David Wilkins, who's faculty at the University of Minnesota in American Indian Studies and does political science work. He came and gave a presentation. I think he might be the only person who wasn't from White Earth who came and presented and did anything with regard to our Constitution. Everything else is a very, very internal process. We're very lucky in the sense that Gerald Bisner, who's a prominent scholar and writer, is a member of our nation, and he was a delegate and agreed after the chairwoman asked several times if he would just be the lead author. He agreed, and then several of us were also on the team and sort of helped out, but we had our tribal judge as part of it, but we didn't have a real strong, our tribal attorneys were not heavily involved. It was really a sort of grassroots people kind of process.
Another thing that I sort of suggested, I think it's very important that the drafting be driven internally and by people who know the community, and either if they're outsiders, that they come in and listen and participate. But also when you're looking at language to use, look at a wide variety of things. Mm-hmm. Look at other tribes, look at First Nations from Canada, look at U.S. states, look at the U.S. Constitution, look at other countries. And ask yourself as well, how have these different constitutions handled different issues? For example, I think it's Costa Rica has a situation where they have a large number of residents who aren't citizens. So they've actually developed a constitutional provision that deals with the fact that they have a lot of people living in their territory that are not citizens. There might be something in there that might spark some ideas or fit a tribe. There are some of the countries in the Pacific where government and military testing was done and use of resources were done. They've put some information in their constitution to deal with those. So there are places outside the United States that have had issues arise that have developed constitutional provisions that might be of interest to tribes and might be relevant. So make sure you take a wide scope of things to look at, but in looking at them, make sure that you make them appropriate to your community.
So, thanks for your words. I've learned a lot actually from the examples that you guys present from your tribes. You know, a constitution can be considered more of a long-term strategic planning document, right? Mm-hmm. Have you guys, in the work that you guys have done, had like maybe strategic planning, like facilitator come in and in more of a transparent way that says, I'm here to facilitate questions and answers and put it all on the board, and then whatever that ends up being, that's what's going to be the rough out of your document. Did you guys have any of that go on? It sounds like
we didn't. That would be an interesting resource, and I think that's something that's developed more recently, especially through Native Nations and Harvard Project have been out doing some of that. We didn't use that process, but I think it could probably be very effective.
The reason why I asked is because I've seen it done two ways. I've seen it done where internally it was people on council that was kind of controlling things, maybe some other community members, some elders, and sometimes their personal interests are reflected in the end product. You know, no, we don't want to change certain things because they may lose power or so on and so forth. And so that can kill a constitution committee, reform committee, easily. Like, you guys deal with that issue?
Our constitutional delegates to the process were all just citizens, and our chairwoman really did the primary facilitating at the constitutional conventions, but the other elected leadership was largely not a part of the process. So they had largely stepped back from the process. So it really was citizen driven. And so we do have some things like term limits on all elected positions, which I don't think necessarily everyone who's currently an elected leader supports, but that's something that the people really wanted. And so I think for us it was advantageous in that they weren't heavily involved. They were not driving the process at White Earth.
I'm just curious, after that process, did they support ratification? Those same leaders who kind of were aloof?
Some of our elected leadership supports the new constitution, some does not.
And for us, I mean, we had, you know, like I said, the committee kind of closed their doors sometimes when they were working, and then it was presented to the tribal council, and then it was presented at community meetings. But, you know, you can tell when there's those political relationships, right? Whether it's with your tribal attorney or with the judge or whoever else, we all know when that happens. And you can see that later on when you say, oh, maybe that's why that was written that way. I mean, you know, one of the things we went to tribal court for was because the tribal chairman thought he had the power to fire our vice chairperson who was elected. So, well, no, they were voted in, you can't fire them. But it says that the vice chair serves at my pleasure. So, I mean, that's an example of you go back and you say, okay, maybe that's why that was put in there. We all say, oh, at the pleasure means, you know, you back me up. And that's kind of how the vice works in any position. So you don't always know that from the outset, and maybe you will never be able to know that in some circumstances. But I think that, you know, maybe going back to your strategic kind of idea is to have people say before you start, well, what is your vision? What do you think's wrong? What's going well? We didn't do that until they already had a model in front of them. So.
Any last questions? Good. Well, I think we'll wrap up so we can have a tiny break before our next one. But thank you.